Greetings and good morning. Let me lower this a little bit for you. There you go. Just wanted to brief you and keep you up to date about what I've been working on, where we're at in Marion, Indiana, with a case that is soon to be had for the restoration of a man's property, which by his right, he has a right to be made whole, okay? And it stems from the preamble. The reason the government was created was to protect the posterity, the general welfare of the people, and government was instituted amongst men to ensure that their right to own property and to control their property was protected. Notice of trespass, October 21st, 2021. Greetings to a woman known to use the name Pam Harris, who at times acts as Grant County Clerk of the Courts with the city of Marion, Indiana. I, man, known to use the name, I'm just going to throw my name in there, Derek Gonzalez. State on October 21st, 2021, you corresponded with I by way of telephonic oral communication at 928 Anti-Meridium. You state orally you will not issue a docket number for the claim of I by way of trespass by way of robbery. I state you claim I must pay a fee for a docket number. I state you claim I must restructure the claim of I before you will grant I a docket number for the claim of I. I state Indiana Constitution, Article 1, Section 12, all courts shall be open and every person for injury done to him in his person, property, or reputation shall have remedy by due course of law. Justice shall be administered freely and without delay. Without purchase, completely and without denial, speedily and without delay. I state Hale versus Hinkle, every man or woman has a right to a redress of grievance. I state Bodie versus Connecticut, due process of law does not require a fee for a redress of grievance. I state there is no law that requires I, man, to diminish the status of I by filing an in forma pauperis form or to diminish the status of I to indigent. I claim you trespass on I, causing I harm by way of denial of due process of law, dereliction of duty, honest services fraud, breach of trust, breach of oath of office, extortion, barratry, mixed war against the Constitution, theft by way of false promise, false and misleading statements, fraud by way of wire, unjust enrichment, and unauthorized practice of law. Further, subject to the Supreme Court case supporting no license needed to practice law, which I do not practice law, ladies and gentlemen, I merely enforce the fucking law. There's a clear-cut difference, all right? The law has been well established since the coming of Jesus Christ, and even before then, in the beginning, the Heavenly Father laid out the law and offered us a covenant, okay? And what these people did in 1302 was created an unum sanctum, which was the first trust man had ever created. But prior to that trust, God had created a covenant. God had created a trust after he had manifested the estate. All right. If you ever get attacked for practicing law without a license, reference court cases. Okay. Now, I don't always reference court cases because honestly, I really don't need to. He who makes the claim has the onus of probandi, and you better be able to prove that I have no right to enforce the law, which is not the practice of law. It's quite the opposite. I merely point out the obvious, and we stand firm on what we are finding of facts and conclusions. Picking versus Pennsylvania, 151, Fed 2D 240, and Puckett versus Cox, 456, second 233. Pro se pleadings. Okay, now pro se is a legal thing. I don't do things in pro se, pro per, any of that shit. I do things as a man, all right? As a man, because men created the government, not pro se, not pro per, not any of this legal jargon, horse shit that they mire you in, okay? But just the same, I just want to show you how they cannot, they can allege all they want that you're practicing law, but they can never prove it, is so long as you know who you are and you're not identifying with their legal mumbo jumbo. Pro se pleadings are to be considered without regard to technicality. Pro se litigants pleading are not to be held to the same high standards of perfection as lawyers, lying, looting, pandering pieces of shit. Okay? Thank God for that, because we operate in honor. We're here to do the good works of our Heavenly Father, and we're not lying, looting, pandering pieces of shit trying to extort the American people by way of false promise. Okay? Platsky versus the CIA, 953 F2D 25. Additionally, pro se litigants are to be given reasonable opportunity to remedy the defects in their pleadings. Okay? I don't make pleadings, I make claims. I'm a man. I fucking claim you did me a harm by way of trespass. You're a wrongdoer, and you can remedy that trespass. I'm going to tap that ass. Rendolson versus Slinger, 907 F2D 124 126, 10th Circuit 1990. See also Jackson versus Circle K Corp, 773 F2D 1138 and 1140. Now people go, well, Derek, why do you read all these court cases if they really don't have any significance? They give me foundation to support what I believe to be a fact, okay? What I believe to be true. And one of the reasons I have that thought process is because when Jesus was at the tabernacle or the synagogue, and they were saying they were questioning his authority, and they were questioning the laws that he was speaking of, and he looked at them and he said, well, aren't your laws the same as my Father's? And everybody's like, ooh. Oh, he makes a good point. Oh, this is blasphemy. This is blasphemy, because the laws, the statutes, the codes, the provisions of Roman civil law that match his Father's law are in fact law, right? Because they're of good sound reason, good sound mind, good sound principle, right? And so who are they to argue? Because are your laws not the same as my Father's? Do unto others as you would have done to you. Love your neighbor as you love yourself. Cause no harm. Are your laws not the same as my Father's laws? And that's blasphemy. He's trying to trick us. No, he's not trying to trick you. He's just simply pointing out the blatantly fucking obvious, you morons. All right. Haynes versus Kern, 992 SCT 594. The respondent in this action is a non-lawyer and is moving forward in propria persona. NAACP versus Button, 371 U.S. 415. United Mine Workers of America versus Gibbs, 383 U.S. 715. And Johnson versus Avery, 89 SCT 747 1969. Members of groups who are competent non-lawyers can assist other members of the group achieve the goals of the group in court without being charged with unauthorized practice of law. All right? Because we're not practicing, ladies and gentlemen. All right? Brotherhood of Trainmen versus Virginia X-Rail, Virginia State Bar, 377 U.S. 1. Gideon versus Wainwright, 372 U.S. 335. And Argersigner versus Hamlin Sheriff, 407 U.S. 425. Litigants may be assisted by unlicensed laymen during judicial proceedings. Howlett versus Rose, 496 U.S. 356, 1990. Federal law and Supreme Court case apply to state court cases. That would be an important one to remember. Federal Rules of Civil Procedure, Rule 17, 28 USCA. Next friend, or amicus curia. A next friend is a person who represents someone who is unable to tend to his or her own interest. All right. And that follows along with equity, aids the inept and incompetent, all right, the legally disabled. Oklahoma Court Rules and Procedures, Title 12, Section 2017C. If an infant or incompetent person does not have a duly appointed representative, he may sue by his next friend or by a guardian ad litem. Maldonado Dennis versus Castillo Costello Rodriguez, 23 F3D 576, First Circuit Court, 1994. Inadequate training of subordinates may be basis for a 1983 claim. Warnock versus Pecos County, Texas, 88 F3D 341, Fifth Circuit, 1996. 11th Amendment does not protect state officials from claims for prospective relief when it is alleged that state officials acted in violation of federal law. Ooh. That just give you the reason to tap that ass right there. There is no such thing as 11th Amendment qualified immunity, ladies and gentlemen. Every man is expected to know the law. All men are required to know the law, for all men are responsible for knowing the contracts they enter into. And quite honestly, there is no such thing as an 11th Amendment immunity for wrongdoers. If you trespass on my rights, causing I a man harm, I haven't a right to redress of grievance, and I'm going to tap that ass personally. I could give a shit less about your bonds commercially. I'm going to fleece you of your house and your fucking home. I'm going to financially lynch your ass, because it's the only thing you tyrants, you yellow-bellied bastards seem to care about. So I'm going to take your house, I'm going to take your boat, I'm going to take your 801k, your 401k, I'm going to fuck you up. That's what's going to happen. And everybody goes, oh, you're so hostile, Derek. I am tired of seeing these fuckers piss on my back and try and convince me it's raining, all while causing harm to my fellow brothers and sisters, and I, for one, will not put up with it. I have an interest in every matter before the court. Furthermore, okay, because a trespass against your right is a direct trespass and encroachment against mine. If they're going to do it to you, they're going to do it to me, and I ain't putting up with it. Title 42. USC, Section 1983, Wood versus Barrier, 54 FRD 710 through 11, ED Wisconsin, 1972, and Frankhauser versus Rizzo, 59 FRD 339, ED Pennsylvania, 1973. Each citizen acts as a private attorney general who takes on the mantle of sovereign. Ooh. When the attorney general doesn't want to do his job, guess what? You just granted me the right to step forward and slay your ass. Okay, lawfully speaking. All right, we're not going to physically cause anybody any harm or go out there and hang them by their testicles, which I think they all should be swinging from dental floss by their testicles. I really fucking believe that, because these people are tyrants, okay? But we are ultimately the ones to blame, and so because of that, it's time that you get learned, all right? Oklahoma is a right-to-work state. Bill SJR1. It's okay to practice God's law without a license. Luke 11:52. God's law was here first. There is a higher loyalty than loyalty to this country. Loyalty to God. U.S. versus Seeger 380 U.S. 163 172 85 SCT 850. Again, I must be about my Father's work. One who brags of his own infamy should not be heard, right? That's a maximum of law. But of course, we know that we're supposed to be righteous men and do the works of our Heavenly Father while we're here. I know that I don't always exhibit that with the language that I use. I would ask for your forgiveness, but there's a time when push comes to shove and some of these things get pushed to the wayside. That doesn't mean that, although claiming to be a righteous man, that I am not a sinner. I sin every day. Obviously, my mouth gets me in a little bit of trouble, but I do ask for forgiveness. And I guess if you're going to recognize that you're sinning in a way that's inappropriate, that you should probably apply yourself in fixing that. So I will work on my language, my foul mouth, as we move forward. But I would like to remind you, shit, by the way, is shipment high in transit, and fuck is fornicating under the king's consent, or under the consent of the king. All right, so these two words that you've been led to believe are bad words actually have they derive from different concepts at a different point in time. The practice of law cannot be licensed by any state. Shawar versus Board of Examiners, United States Reports, 353, U.S., pages 238, 239, and Sims versus Aharns, 271 SW 720 1925. The practice of law is an occupation of common right. A bar card is not a license. It is a dues card and or membership card. A bar association is that what it is, a club. A association is not license. It has a certificate, though the two are not the same. Non-lawyer maxims. Member of a group who are competent non-lawyers can assist other members of a group to achieve the goals of the group in court without being charged with unauthorized practice of law. No state shall convert a liberty into a license and charge a fee therefor. The practice of law cannot be licensed by any state. The practice of law is an occupation of common right. Litigants can be assisted by unlicensed laymen during judicial proceedings. There can be no sanctions or penalties imposed upon one because of his exercise of constitutional rights, okay? And that should state constitutionally protected rights, because the Constitution doesn't grant you any rights, ladies and gentlemen. It's such an egregious misnomer. It's troubling. But again, I'm going to read you one more time. If you're following along with me on the development of what's transpiring in Marion, Indiana, this is to the clerk of the court. I am not finished with it yet. It is, of course, all handwritten. Notice of trespass, October 21st, 2021. Greetings to a woman known to use the name Pam Harris, who at times acts as Grant County clerk of courts with the city of Marion, Indiana. I man known to use the name, I'm just going to fill my name in there, Derek Gonzalez. Stated on October 21st, 2021, you corresponded with I by way of telephonic oral communication at 928 Anti-Meridian. You state orally you will not issue a docket number for the claim of I by way of trespass, by way of robbery. I state you claim I must pay a fee for a docket number. I state you claim I must restructure the claim of I before you will grant I a docket number for the claim of I. I state Indiana Constitution Article 1 Section 12, all courts shall be open and every person for injury done to him in his person, property, or reputation shall have remedy by due course of law. Justice shall be administered freely and without purchase, completely and without denial, speedily and without delay. I state Hale versus Hinkle, every man or woman has a right to redress a grievance. I state Bodie versus Connecticut, due process of law does not require a fee for a redress of grievance. I state there is no law that requires I, man, to diminish the status of I by filing an informal pauperous form, or to diminish the status of I to indigent. I claim you trespass on I, causing I harm by way of denial of due process of law, dereliction of duty, honest services fraud, breach of trust, breach of the oath of office, extortion, barratry, mixed war against the Constitution, theft by way of false promise, false and misleading statements, fraud by way of wire, unjust enrichment, and unauthorized practice of law. Now let's get into these claims real quick. The claim of trespass by denial of due process of law is the fact that she refuses to give the docket number to us because she feels like there's a fee associated with justice, all right? And there is not, maybe in the legal realm when you file a complaint, but let me just ask you this. How many DAs do you actually think shell out $183 every time that they want to file a claim in Marion, Indiana? They don't. Okay, when they file a claim on behalf of the state, these cocksucking rat bastards are not paying anything. So why the fuck do I have to pay anything for the interest of justice? But these assholes, these lying, looting rat bastards that are stepping in without a real party of interest, bringing a false and fictitious claim without firsthand knowledge, don't have to pay a fee, but I have to pay a fee when I make a claim. Kiss my ass. That's mixed war against the Constitution. Okay, that's dereliction of duty. That's making a legal determination, which is the unauthorized practice of law without a bar card. Okay. Secondly, I'm not in your arena. I'm not in the public venue. I'm in the private. Okay. And you better learn real quick or I'm going to hit that pocketbook. I'm going to hit it. I'm going to hit it. I'm going to hit it hard. And everybody in this community is going to know there's a new sheriff in town. And I mean business. And the only thing that bothers these people, they don't give a shit about going to jail. That's not even a thought in their mind. All their friends are judges and attorneys. They're not worried about going to jail. But I have to tell you something their judge buddies and attorneys can't save them from. And that's the flat out fleecing of their estate. And I'm talking about their 801k, their 401k. Okay, so let's get further into this. Dereliction of duty. She has an obligation the second that she has those papers in her hand to file them. In fact, they are considered filed the minute they touch her hands. Boom. No questions asked. It doesn't require a fee. It doesn't require an explanation. It doesn't require anything. The second those documents hit her hand and we are bringing forward a lawful claim, she has a rights, titles, duties, and obligations to we the American people to put a docket number on there and to allow a judge, a ministerial administrator sitting on the bench who's an expert in property law. Why property law? Because rights are property and property are rights, period. So with that said, she has a duty, a fiduciary duty to give us and issue us a docket number for which we can move our court and we can put our statement of facts into, and then we can move our court as to what date, what time we plan on having a ministerial administrator sit on the bench. Okay? So by her denying us that, she's denying us due process of law. Let's go on a little bit further. Honest services fraud. Honest services fraud is something that the Bar Association put out years back to every lawyer. All lawyers got this. Now, shortly after Mr. Anonymous tracked it down and found it on the internet, poof, it magically disappeared. Imagine that. Okay. Breach of trust. Okay. Breach of trust is breach of the public trust. She has a duty under her oath of office to perform her task post haste and her assignments without any postponement. Okay. Because justice should be swift and never delayed. It's right there in the Indiana State Constitution. Breach of oath of office. How's she breaching her oath of office? By failing to do her job and being derelict in her duties. Her job is to make an observation, create a record, and issue a docket number. That's it. On such and such days, such and such man or woman walked in here, dropped off a claim of harm by way of trespass, and I have a fiduciary duty to issue a docket number for him. We'll let the judge decide whether or not they've got a valid claim. Okay? Extortion. Extortion comes in the form of a fee for justice. I don't owe you a damn thing. Furthermore, you can't qualify nor quantify the specie of payment that you want. Okay, you can't pay a debt with a debt, and I'm not obligated to give you FRN notes, and you can't specify that you want Federal Reserve notes. For Federal Reserve notes are only for bank-to-bank transactions. So again, you want me to pay what? $183? Okay, well, I just need you to give me a bill for the goods and services rendered. I mean, a true bill due and owing. You go ahead and show me how I am somehow obligated to you to pay you anything when the primary active degree of fault falls on the President of the United States under Title 18, subsection 8. And oh, yes, ladies and gentlemen, I know damn good and well what I'm talking about, all right? So, baratray. What is baratray? Baratray means that they are extorting us, okay, under the guise that they don't work for us anymore, and they're mismanaging their ship, and we are the owners of it, and they're trying to charge us a fee. That is baratray. It's a fee for justice. Is baratray. Mixed war against the Constitution. Well, how would she be involved in mixed war against the Constitution? 1, the unauthorized practice of law. 2, dereliction of duty and breach of her oath of office and breach of the public trust would be mixed war against the Constitution, because the Constitution clearly states for the state of Indiana that justice shall be administered freely and without delay and without purchase, completely. Every state is the same way, okay? And until Carl Lentz had mentioned on the internet that the U.S. Supreme Court website actually said that every state is a commonwealth state, and every state has common law courts. All courts are common law courts for the Commonwealth of Indiana, Ohio, Nevada, Texas, you name it. Well, shortly after Carl Lentz got online and was squawking and talking about that and drawing everybody's attention to it, poof, it magically disappeared off the Supreme Court's website. Now, I want to tell you, just because they take something off the internet and whitewash the internet does not mean the fact is not still a fact, ladies and gentlemen. It is absolutely a fact that we have a republic, and like Benjamin Franklin said, you can continue to enjoy that republic if you can keep it. Now, why did he say if you can keep it? He was telling that woman, if you know how to handle your business, if you know how to conduct yourself, you are self-governing, and we have implemented for you. When he wasn't even a member of the Congress at the time, he wasn't a sitting member of any body of politic when he borrowed the money from France to start the USPTO, ladies and gentlemen. He made sure there was a republic for us, which means that we have a right to govern ourselves. Consent of the governed. We have a right to press our claims. Okay? So, mixed war against the Constitution. That's another charge. Theft by way of false promise. How is this clerk of the court engaged in theft by way of false promise? Okay, she's engaged by theft by way of false promise because she has rights, duties, and obligations to the American people, and she's taking her income under false pretense, which is unjust enrichment. Okay, so she has pledged an oath to the American people to execute her duties to the best of her ability, knowingly, willingly, and intentionally executing her job in the interest of the American people so they can bring their claims forward in the court. Okay. And so she's taking her income under false pretenses, which means that's theft by way of false promise, while she's attempting to extort us in an act of barratry and mixed war against the Constitution. False and misleading statements. Well, when you tell me that, I just can't do this because the structure of your document does not meet our court's requirement. Well, little lady, let me tell you something. I'm not in your venue. I don't know how many times I'm going to have to tell you that I'm not in your venue. I'm on the private side, okay, not the public side. This is not a matter of public. This is a matter of private. I don't have to restructure a damn thing. Now, that's the unauthorized practice of law by you giving me legal advice, telling me that you're not going to give me a docket number, which is your only fucking duty, because you believe the form is incorrect. Let me advise you real quick. Equity disregards the form and looks at the substance and the fucking intent of the subject matter, period. So your claim, your making of legal determinations is causing I harm by way of false and misleading statements because you don't know what the fuck you're talking about. Okay, and under Title 1578 FF, false and misleading statements come at a $100 million fine, and under Title 151692E, they also come at another $25 million fine. So you should be probably pretty careful about the words coming out of your mouth while you're making legal determinations without a bar card, while in your official capacity, in breach of your oath of office, involved in mixed war against the Constitution and war against the people of the United States of America, because we're still here. Okay, you might be operating for a subsidiary corporation under the United States, but the United States of America is still alive and very fucking well. And we're going to tap your asses for it. We're going to let you know we are learning, and we see what you lying, looting, piece of shit, scumbag fuckers are doing. And I'm going to tell you what. Nobody wins a war with bullets, knives, guns, guts, and glory. You know how you win the war? You win the war like this. And I'm going to teach everybody how to do it. Fraud by way of wire is a Title 18, 1341, 1342, 1343 trespass, okay? And I don't like to use statutes, codes, city ordinances, rules, and regulations in my common law claims. All I'm simply saying is fraud by way of wire. Do not your laws reflect as the same as my father's laws? Okay, now everybody's going to say, well, God never had a cell phone, Derek. Okay, well, let me just tell you something. There's nothing new under the sun. If God didn't intend us to have telephonic communications, trust me, we wouldn't have them. So, fraud by way of wire. Where you purport and allege to know the law, to extort me by way of wire, to address the issue by way of wire, and failing to put it in writing. She absolutely denied to put her finding of facts and conclusions of law and how she made legal determinations not to provide a docket number. She absolutely will not do that and sign her name to it. So again, it comes under false and misleading statements and fraud by way of wire. unjust enrichment. How's she unjustly enriching herself? Because she's not doing her job and she's taking her income under false pretenses. And that, ladies and gentlemen, is unjust enrichment. And the American people of Marion, Indiana are all rightfully due and owing their tax dollars back. Okay. Now, in hindsight, I know that everybody pays themselves through their exemption account, through the Social Security Administration. I'm not fucking retarded. But the American people seem to believe, for the majority of them, that the tax dollars pay for these cretins to do what they're doing. But in all actuality, they're paying themselves. But nevertheless, that would still probably stand if I push the issue, because they don't want to let the cat out of the bag. Can't be telling people everybody's paying their own wages. Unauthorized practice of law. Well, I think we pretty much covered that when she made a legal determination, absent a bar card, absent 7 years of schooling, and then she alleged that some judge told her that she didn't have to do her job, which means that she went to a judge. She's incompetent to do her duty because she had to seek the advice of somebody else who isn't purported to do her job. And they said, well, you know what? You don't have to give him a docket number. Well, sure, that's true. And just the same, I could tell a kid that you can put tweezers into a light socket and it's not going to hurt you, or into an electrical receptacle. I didn't say that I could say you can put them into an electrical receptacle and they can go do it. I didn't say that it might kill them. I didn't say that it wouldn't kill them. All I said is you can do that. So a judge telling this clerk of the court that she can do a certain thing is egregious. One, she puts this clerk of the court in harm's way by her advice, if you will. But she never explains to her the difference between general liability and personally liable. Now, when the clerk of the court is operating outside the scope of her office, now she becomes, instead of generally liable, which the principal carries most of the inherent risk, now she becomes personally liable, which means it's all about her personal bank accounts now. See, the insurance company is going to tell me, hey, look, Derek, you're a sharp cat, but here's the deal, Scooter. Unfortunately, when she made those determinations, which she's not qualified to do, she was operating outside the scope of her authority. And because she was operating outside the scope of her authority, she is now 100% personally liable. So although we may see your claim and we may agree with you, our principal is not liable for paying you out for the harm, loss, or damage that you have incurred from her dereliction of duty because, well, you see, she was outside the scope of her authority. So you actually have to hold her personally liable. Now people go, well, how do we get a list of their assets? How do we move forward, bringing forward an adequate claim and knowing what we can actually bill them up for? First of all, you can bill them whatever the hell you want. Secondly, if you're having a hard time getting a list of their assets, just require a 433A and a 433B filled out from the IRS. And again, that's a 433A and a 433B. That will give you a list of their business assets and their personal assets. And then, ladies and gentlemen, just practice your writs of execution, because once you get this process down, it is so simple, so eloquent. There is no need to argue. I'm not arguing here. You rebut these statements of fact point by point by point, or on this next page, you are going to get a true bill due and owing. And the true bill due and owing will accompany this document. And she will be served with this today. So what else can we point out to you? We went through the unauthorized practice of the law. We went through a non-lawyer maxims. We went through a number of court cases here. One that I want to draw back to your attention is federal law and Supreme Court cases apply to state court cases. I can't tell you how many state court venues I've been in, and the ministerial administrator goes, yeah, well, the Supreme Court cases are a nice idea, but I don't have to abide by it. Again, this is in legal land, Supreme Court cases, but the Supreme Court cases typically are the law of the land. They are in support of the Constitution, all right? Now, these federal judges will absolutely spank these guys, guaranteed. Guaranteed. They might not like having to spank their fellow constituents, but I promise you they won't have a choice if you know how to write up your claim. So thank you for joining me this morning. Again, freedom isn't free. Be willing to go to jail. Be willing to fight to your dying breath if need be physically, but I'm telling you there's a better way. There's a better way, ladies and gentlemen. This is coming from a guy who's extraordinarily physically aggressive. If you read anything about my police reports or my past and my history, you will clearly see that I am not a flight kind of guy. I'm a fight kind of guy, and I've always been that way. But I had to learn how to simmer it down, tame it down, control that animal within me that always wants to physically just beat the shit out of stupidity, because you can't fix stupid by beating the fuck out of it. It sure is fun, all right? And I'll be the first one to admit that, but it never fixes stupidity. Stupidity will still exist no matter how much you beat the shit out of it. You just can't get right enough to get him to change his way of thinking. Some people are just willfully ignorant. They're always going to be that way, all right? Speaking of, there's another fun fact here. Maybe I shouldn't do that. It's a little politically incorrect. Yeah, not going to do that this morning, but if you watch Django sometime and they pull up to that guy's house because he wants to buy a lady, right? And it's the dentist and Django. Django's on a horse. And they say, oh, you can't have that man on a horse. They use explicit language I'm not going to use because I just hate the word. I'm just not going to use it. And he says, now, Django is not a slave. Django is a free man. Now, I want to show you status correction here. All right. Or limited status correction, because it's exhibited in the movie Django. And it's so funny. The more I think about it, the more I laughed yesterday. Because I know the clerk of the court in Marion County was probably summoned to the Attorney General's office for extra training. Now, you see, Django's a free man. Oh, so boss, you want me to treat him like a white man? No, I didn't say that. You know that boy at the candy shop? Yes. I want you to treat him like that. Oh, you mean the kid that ain't all right in the head? Yes, just like that. So you're not going to treat him like you treat me? No, sugar. You're going to treat him like you treat the boy at the candy shop. That was a limited status correction that is being exhibited in the movie Django, where he doesn't quite have the status of a free man. He's got the status of a special man. Okay, so just pointing that out. Go watch the movie Django, and when you see that part where they're trying to acquire a woman or whatever, and that reminds me of what they're doing to these clerk of the court and prosecutors when they end up encountering me. They call special meetings. Now that guy Derek, you can't treat him like all the other slaves. That man is a different type of man. So you're saying he's free, boss? No, he's still under our authority. But I want you to treat him like that other guy over there that's a little more privy. But I don't want you to treat him as though he's free or that he's sovereign, because, we still have control. Once you break the chains that bind you, ladies and gentlemen, it is so comical to watch these people shake in their boots, literally physically shaking. I had a deputy sheriff the other day doing this while he was throwing out slanderous verbiage, alleging that I was a sovereign citizen. Well, let me get this right. If you purport for me to be a domestic terrorist, I hope that you have substantial evidence to affirm your claim. And if you do have substantial evidence to prove that I'm a domestic terrorist, then why are you derelict in your duty and don't have me in cuffs and in a cage right now? Because you fear that I may be either in the commission of a crime, about to commit a crime, or have committed a crime. I hope you can prove your claim. You're being awfully fucking ignorant, uttering words out of your mouth, not knowing the repercussions and the ramifications of your action through your slanderous ways. It won't work in your favor. Now, I'm sure he had a meeting with the sheriff the other day, because they're all squawking and talking about me here now. I never really gave them my name, but the other day on the phone they said, Derek Gonzalez, we know exactly who you are. Well, it's about time you figured that fucking out. It didn't take you long with that facial recognition. I'm surprised that it took you as long as it did. And yes, I'm in town, so you should probably have an emergency meeting with all of your constituents that you're trying to lord over on this plantation. You better have complete evaluation of your conduct, because while I'm here, I'm going to have all kinds of fun billing you guys up for your dereliction of duty, breach of public trust, honest services fraud. Okay? So thanks again for joining me. We'll talk to you soon. They don't like you, brother, and I don't like them. Doesn't matter. You know what? I don't have any ill will or animosity to them as a man or woman, so long as they follow the fucking law. It's that simple. Follow the law. If you're telling me that you're just doing your job, I can guarantee you that morally you know what you're doing is wrong. Anybody that ever tells you I am just doing my job knows morally that what they are doing is wrong, and that is a trespass by a wrongdoer causing you harm. Period. And it's just a matter of identifying it. So remember that. Every time an agent and agency says, I am just doing my job, they know that ethically and morally what they are doing is wrong. I love you guys. Have a wonderful, blessed morning. As you know, I got work to do. I got another half a page to finish this up. I'll throw some maxims of equity in there and let them know that, you know what, you didn't want to file a court case here and give me a docket number. We filed the claim. It touched your hands. You had a duty and an obligation to record it and to file it received and to give us a docket number and not make legal determinations. Now I'm going to take your ass to federal court. I think I'm probably going to hit you for about 50 to 60K. And by the time I'm done, it should take less than 30 to 90 days. There will be a check sitting in our pocket. I promise you that. And the federal court system is not going to dilly-dack around with me about form. They're going to look at the substance and intent and go, yeah. Clerk of the court, give him the docket number, please. Do not fuck around with this guy. Jeez, or Pete, we do not want this nightmare on our hands. Because although I'm not a lawyer, I'm extraordinarily learned, and you can be too. Thanks for joining me. We'll talk to you soon.